Now, on 105.9 FM and streaming worldwide on the WMAL app. O'Connor and Company.
It is 7:07. It's O'Connor and Company this Monday morning, 15th day of December. We'll get you updated on everything we know about that terror attack in Australia, about the shooting at Brown University and the suspect still at large. And, of course, with the horrific news out of Hollywood, the murder of Rob Reiner and his wife Michelle at the hands, it appears, of their son. Just a crazy way to wake up this morning. We'll get you read in on all of it so you can get along with your day, knowing what you need to know. Coming up at 8:05, Phil Wegman, White House correspondent for Real Clear Politics, and then at 8:35, Chuck Thies on the new revelations about the D.C. police chief who just retired. It's Larry O'Connor with Julie Gunlock. Good morning, Julie.
Good morning.
And it's Monday at 7 o'clock. That means it's Joe diGenova time. Good morning, Joe. Good to talk with you.
Good morning, Larry, Julie.
Joe, gosh, there's a lot to get to, but there was one moment that I thought of you immediately because you have such great respect and admiration for one Mark Elias, attorney here in Washington, D.C., who for some inexplicable reason decided that he would argue a case before the Supreme Court. And Justice Clarence Thomas asked a very simple question. Can you please explain? This has to do with the Republican Senatorial Committee and a ruling by the FEC having to do with expenditures. And Clarence Thomas asked him a question, well, isn't there a speech component to spending money on a campaign, be it, hotel rooms or ads or what have you? And Mark Elias goes on this 2-minute just rambling word salad that would make Kamala Harris blush. And Thomas comes back and says,
I still don't understand what you're saying. If the party coordinates with the candidate.
Yeah, you don't need to hear any more. I said that's just a devastating. I still don't understand what you're saying. What did you make of these arguments and the disposition of this case, Joe?
Well, this is the inevitable result of the Supreme Court having ruled some time ago in the Citizens United case that money is speech. It's very simple. And that this is common sense to the average American, that when you spend money on campaigns in the modern era, you cannot speak without money for the most part. You cannot buy ads. You cannot buy television and radio time or internet services. Right. And so Mr. Elias, who is against allowing more coordination between independent committees and candidates, could not answer the question because he could not deny that money is speech, and so he ended up giving a very stupid answer, and it couldn't happen to a nicer guy.
Yeah. Exactly. It was a brilliant moment, not only to show how great and droll Clarence Thomas can be, but also just what a blithering
Yes.
idiot Mark Elias is. Earlier in the week, though, on Monday, and you and I, we previewed this last Monday, the Trump versus Slaughter case. This has to do with the president being able to remove people from these so-called independent agencies. You suspected that the court would look upon that rather skeptically and retain that power in the executive branch. Did the arguments go the way you thought they would?
Yes, they did. I assume this is going to be a 6-3 case with the three liberals voting against the majority. This is a case in which the question is, what or who is the executive branch? The answer is in the Constitution in Article 2, where it says, and I quote, "The executive power shall be vested in a president of the United States." That is the entire verbiage in the Constitution about the executive branch. There's some other minor language, but that's it. And what does that mean? According to the unitary theory of the Constitution, it means that there is one executive, and he has or she has power over the executive branch. Otherwise, the separation of powers doesn't make any sense. Well, Woodrow Wilson and Franklin Roosevelt decided that they liked something called independent regulatory agencies. And they said the president can't fire these people except for cause. Well, if you're the president of the United States and you're the only person mentioned in the Constitution, and there's no word in the Constitution about independent regulatory commissions, who do you think's going to win? The answer is the president's going to win, and the Supreme Court is going to rule that maybe with the exception of the Federal Reserve, because it's a bizarre animal that's more private than it is public, that the independent regulatory commissioners can all be fired because they work for the President of the United States. And if they don't work for him, they're not in the executive branch. So great case. It's been hanging around since 1935 with that crazy case called Humphrey's Executor. And very poorly written case, Humphrey's Executor. It was designed to screw Franklin Roosevelt. It wasn't designed to set constitutional law.
So, Joe, will this sort of be the beginning of the end of what we know of now as the deep state? Is this, I mean, the left has been trying to find these federal judges to get in the way of President Trump firing people and reconstituting and reorganizing various aspects of the executive branch, which, if you look at the Constitution, seems to be completely within the executive's power. They have forced these issues to the Supreme Court, and it appears as though the Supreme Court continues to side with the Constitution and therefore with President Trump and the executive branch. Will this next one sort of be the last one that Trump needs to really sort of reform the executive branch as we know it?
Well, it certainly will be the biggest brick in that wall yet. Once he can fire the commissioners, then it is only the slightest step to say that the Civil Service Reform Act of the 1890s and the 1960s and the 1980s, Jimmy Carter's Civil Service Reform, that all of those laws are unconstitutional. That you cannot say that a president cannot fire any employee of the executive branch. I mean, that's where we're headed. The president's going to win. It's all over. And it will certainly help destroy the deep state, just like cutting the budget has helped destroy the deep state. But remember, the deep state is still around. They're embedded. You can't fire them all because you got to have somebody to run the government. And once you have somebody, you've got a problem.
Oh, go ahead, Jules.
No, do you have more on that? Because I was going to ask.
No, I was going to switch, so go ahead.
Well, I just the other court case we're interested is this court case on pro-life centers pushing back on the state, I guess it's New Jersey, asking for donor information and saying that it violates the right of association. This is a big intimidation move. Do you think the Supreme Court will rule the correct way and support the ability of these pro-life centers to keep these donors quiet or sort of not exposed?
The Supreme Court is going to rule that the pro-life centers do not have to give the governor and the attorney general of New Jersey their donor list. Now, why does the governor, Phil Murphy, one of the dumbest governors ever elected in the United States, and the attorney general of New Jersey, why do they want those pro-life center donor lists? Because they want to discourage people from giving to those places. The Supreme Court figured this out way back in the 1960s when it ruled in the Southern cases that the NAACP did not have to reveal its donor list for the very same reason. If you reveal the donors may very well stop giving, and that will influence free speech. This case that New Jersey brought is so stupid constitutionally and so wrong-headed that I just wish that the court sometimes would not just reverse, but reverse with a vengeance and say, you should be punished for this, and there should be sanctions against the Attorney General and the Governor of New Jersey for bringing cases that are so ill-founded.
Joe, quickly, Letitia James, it looks like a grand jury has returned no indictment now for the second time in a row. Is that case still viable?
Technically, legally, it is. Whether or not it is viable is, in fact, a really different question. I don't know enough about what in the world was going on in the minds of people to bring these cases in the Eastern District of Virginia and Norfolk. First of all, the Eastern District of Virginia is Washington, D.C. The population there is no different than the population of Washington, D.C. It's the same liberal left Democratic Party, and that's what you get in grand juries and petit juries in the Eastern District of Virginia and in many parts of Virginia. So the better thing to do would have been to save all these cases, even the one with Jim Comey that was limited by a statute of limitation. Just take your time, bring the cases down in Florida where they belong, where Mar-a-Lago is, Mr. Comey can be a defendant there. So can all the other people you were targeting. As far as Letitia James is concerned, you got to do it right. Although I do think that they did it right, and I think that the judges in the Eastern District of Virginia did a horrible, horrible job. They're very, very anti-Trump. It's a bad scene. Again, bad venue. Don't bring cases there.
We got to leave it there. Joe diGenova, have a great week.
You too.
It's 7:16.